I ask unanimous consent that the gentleman from Texas, Mr. Green, be recognized for 5 minutes. Without objection, the gentleman is recognized.
Thank you, Mr. Chairman. Mr. Cordray, are you a lawyer?
Am I a lawyer?
Yes, sir.
I am. I haven't really been active in practice for a while, but yes, I'm
Yes,
a lawyer.
sir. And as a lawyer, do you understand that a settlement is an agreement?
Yes, it is.
And an agreement, by definition, means that parties have reached a conclusion that they find themselves amenable to, such that they can go forward with that conclusion. Is that a fair statement?
I think that's fair. It doesn't mean they all agree with each other on all the subparts, but yes, I think that's fair.
And is it true that in the Ally case, there was an agreement, a settlement, and that, which means that the offending party, this is my terminology, agreed to certain penalties and certain payments such that this could be resolved and such that persons who had been harmed could be justly compensated?
And notably also certain changes in their practices going forward, which may be more valuable in the long run than the payments made.
But the gravamen of my contention and the gravamen of this discussion is agreement. This is not something that the party who has now found itself in a position to make these payments, is not something that the party refused to do, refused to sign, said, I won't deal with you, take me to court, I don't want to cooperate with you. There was a certain amount of cooperation in this. Is this correct?
Yeah, could have done that, and they didn't.
They did not. And here is what I find from my review of some intelligence. The CFPB and the DOJ determined that more than 235,000 minority borrowers paid higher interest rates for their auto loans between a certain period of time, April 2011 and December 13, because of Ally's discriminatory pricing system. Now, this is not something that Ally had to acquiesce to. This is something Ally chose to do for whatever reasons. It chose to do this. And by the way, Ally is not without a battery of lawyers. Is that a fair statement?
That's a fair statement.
And their lawyers, I assume, are capable, competent, and qualified persons who could easily decide that this is better suited for litigation than for some sort of settlement resolution. Fair statement?
I think so.
So, I see in this, the largest ever settlement in an auto loan discrimination case, I see this in this an opportunity for us to send a message to others that if you discriminate, we're going to come after you. This is lawful, it is ethical, it is righteous. People who discriminate ought not be allowed to do so with impunity. And others ought to get the message that if you do it, you too will have to pay a price. I find very little to complain about with this decision because the party paying agreed to make the payments, agreed to this settlement, which, by the way, is large. But when you do a great amount of harm, you should pay a great amount in penalties. I'm showing here that 18 million in civil penalties were agreed to. So, Mr. Cordray, if you have a conversation about your options, is that in some way unethical if you talk about options in rulemaking? My assumption is that you would look at the entire range of options when discussing rulemaking. Is this true?
I don't think we could act responsibly if we didn't discuss all the options and then try to make our best decision, which may or may not be the right decision. Somebody else might disagree, but yes, we talked through the options. And I don't think there's anything wrong with that, and I think it's the right way to proceed.
And in talking through options, do you sometimes talk about options that the industry might not find favorable?
Sure.
Do you
More
also
or less.
sometimes discuss options that consumers might not find favorable?
Yep, I'm sure that's the case.
But that's your duty.
Yeah.
I yield back the balance of my time.
Chair now recognizes